Hello, my name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors. I'd like to welcome you today to our first of many to come presentations online this year 2025. Today, I just thought to start on something that is simple and something that some people sometimes don't understand, and some people don't actually read through if they receive it. Today, we want to talk about the employment contract here in the UK. So whether you're on a fixed term contract, a flexible contract, a 0 hour contract, whatever you call it, you receive an employment contract if you're working in the UK. Some people will call it a statement of employment, an agreement of employment, different terms, different names, but effectively it's an agreement between an employer and an employee, the terms and conditions that are relevant for the employment agreement. The employment agreement is important because in the event of a dispute, the employment contract will protect you, either party, the employer or the employee. I sometimes see people that have not signed their contracts or they delay signing their contracts and they do not understand their contract of employment. The employment of contract usually comes with an employment handbook, or some will call it a staff handbook or an employee handbook. And also attached to that sometimes might be some certain policies and procedures. So it is important if you're an employee for you to understand what sort of employment contract that you have and what other documents should be read in conjunction with the employment contract. And in most cases, the employment contract would be referring to a staff handbook or an employment handbook, which is also important for you to understand. Not only is it important for you to understand the employment contract, it's also important for you to have a signed copy in your possession and also to have a copy of all the relevant documents, such as the staff handbook, the policies and procedures. Because in the event of a dispute and the employer is logged you out of their systems, it might be difficult for you to be able to then retrieve these documents, unless if you are going to make a subject access request from your employer so that they can release a copy of your file to you. So I'm just going to go through some basic terms in terms of the employment contract. So the employment contract will mention the parties involved. So in the employment contract, we'll have the employer will be represented by a member of the management and the employee. So the name of the employer, the name of the employee, contact details, addresses should be information that I would expect to find in a basic employment contract. Make sure that your details are recorded correctly, and if you have moved address or changed contact details, you keep it up to date with the employer. And if you are a sponsored worker, then you would also want to update your details with the Home Office. You should make sure that the employment contract is recorded the correct job description, the job title. What is your title? And it is also recorded the start date. The start date is important because in the event of a dispute, then you will know when you started, and your dues will be calculated accordingly from the time that you started. The current law says that anyone who has worked for more than 2 years might potentially be able to bring a claim for unfair dismissal against the employer. But if the start date is not recorded, then it might be difficult to prove that you've done the 2 years. This is something that is going to change in the future because the Employment Rights Bill is going to change the unfair dismissal to be a day one claim once it is implemented. It is also important to make sure that your eligibility to work in the UK is included in the contract of employment. This will help you or the employer to show that you have got all the requisite rights and privileges to stay in the UK and to work. The contract should also outline your duties and your responsibilities, and this is normally also included in your job description, your JD. So read your job description as well in light with your employment contract. The description should match what you've agreed with the employer. And it should also have a reporting structure and a commitment to the company policies. A contract of employment would normally have a probation period. Some people will have a probation period of about 3 months, some of 6 months. And once the probation period is about to end, you will have a meeting with your management who will confirm that you've passed the probation, or might say that you have not passed the probation and they might terminate your employment, or alternatively, they might extend your probation period. So make sure that you agree on the employment contract probation with your employer. The contract would also mention notice period for the probation, or during the probation period, or in the first year, the second year. The notice period is cumulative in accordance with the number of years that you have worked for an employer, and it will come to a maximum usually of about 12 weeks. Um, yes, 12 weeks, depending on the period that you have been working for the employer. So make sure that there's an employment notice period in the contract as well. You have to agree on the working hours with your employer. So if your work is 9 to 5, you agree that you're working 9 to 5, you're working 37.5 hours, 40 hours, or if you're going to opt out of the working hours regulations, you will do that through an agreement with the employer. If you work in an industry such as the domiciliary care, where your hours might be might appear to be more hours because you are driving in between your calls, or in between your calls you are taking rest period, you really need to agree with your employer as to what are the working hours, the driving hours, the resting hours in between, and so forth. So working hours should be agreed. And if there's any flexibility, you need to agree what sort of flexibility is there. Flexibility is something that is also going to be changed in terms of the Employment Rights Bill, which is going to come, or which is being debated in Parliament. And their flexibility will almost be of right, and the employer cannot refuse to give flexibility, or should mention the reasons why they are not giving flexibility. So where it is possible to have flexibility, the employer should offer that to the employee, when requested, or when it is really necessary for it to be done. Salary. The contract must also mention the agreed salary. It can be mentioned in terms of an annual salary, or as per hour, if you are getting paid per hour. And if it's even a 0 hours contract, it should be clear as to what the salary is and how you are going to be paid, when you are going to be paid, direct debit, transfer to your bank, weekly, for fortnightly, or monthly. It should be clear. It should also be clear what sort of deductions are going to be taken from you, and these deductions should be lawful. There's been a lot of controversy about unlawful deductions that has been done by some employers to their employees, and it should really be clear between the parties from day one as to what are the deductions. There's the obvious deductions such as the NI, the tax, and so forth, maybe um, pension, but there is other deductions that needs to be clarified between the parties. Place of work. If your place of work is fixed, then you need to agree on what place of work it is. It might be mentioned to be your head office, but you might not necessarily be working in the head office. You might be reporting to the head office, but going about into different areas. For example, if you're a driver, you're delivering stuff. If you're a carer, going to people's houses and so forth, but you've got an address that you are reporting to. Or if you are going to change your address, or reporting address where you're going to be working from, then that needs to be clear as well. So place of work needs to be agreed, and if there's any other potential locations that you're going to be working to or from, that needs to be mentioned as well. Holiday entitlement. Holiday is not a privilege, it is an entitlement. Everyone is entitled to rest, and the well-being of everyone is important. particularly if you are working and you've got family, you've got other responsibilities. Even if you are single, your own life is also important. So holiday should be made clear. On flexible contracts such as 0 hours contracts, normally holiday is accumulated. It's accrued according to the hours that you work. But however, on certain contracts that are fixed hours, the holiday is already calculated. So you in the basic hours that you, or in accordance with the basic hours that you're going to work, or in accordance with the agreement that you have with your employer. So most people would be entitled to 20 working days plus the 8 public holiday days that are there. Some jobs might not allow you to work to rest on the public days, or bank holidays as we call them. So you might work during your bank holiday, but you still be entitled to your holidays. And normally it's about 28 days. Some people agree for more days than that. And if you've not taken a holiday, it has to be agreed whether you're going to be paid in lieu of the holiday, or if there's no payment in lieu of the holiday, do you forfeit your holiday? But it is important for everyone to have their own holiday. So the holiday needs to be agreed. If there's any carryover policy, that needs to be mentioned. So if you carry over your holiday from this year to next year, it has to be clear. And we know that in the COVID time, people were carrying over holidays or having extended holidays and so forth. But now, since COVID is over, we just need to make sure that the holidays are properly calculated. Employers these days will give you an app that you put on your phone that will enable you to book your holiday through the app. You need to calculate how many days or hours that you have outstanding on your holiday. Sickness absence. It's important that the sickness policy is clear, and sickness absence is also mentioned in the contract, although there might be a separate sickness policy in the employment handbook or as a separate policy in its own right. You need to agree as to what happens between day 1 and 3, and when SSP or sickness pay kicks in, and for how long it's going to be paid, and how you report your sickness, who do you report your sickness to, and when you do your return to work interviews with who and so forth. That needs to be made clear. Again, this is another um, thing that is going to change in terms of the Employment Rights Bill, whereby SSP, the statutory sickness pay, is going to be a day one right. At the moment, it is not. It normally kicks in on the fourth day. And again, in terms of sickness, we know that you self-certify yourself for the first 7 days, and after that, you need to get medical fitness, not to show whether you are still not fit to come to work, and so forth. So you need to comply with these laws. If you're not still able to go to work after 7 days, you need to get the note from your medical team, your GP, so that you'll be able to give it to your employer to justify your time of work, so that it will be considered as authorized absence from work. Unauthorized absence from work might lead you to being disciplined by the employer. Worse still, if you are an immigrant on a sponsored visa, if you are reported by your employer that you are on an unauthorized absence, if it has gone for more than 28 days, that might also have implications on your visa. It might be curtailed because of that. So we need to have an understanding as to the SSP, the sickness policy, sickness absence, and so forth. Pension. The proper procedure with the pension is that the employer will opt you into a pension scheme. That is you have to be um, put into a pension scheme, and the pension scheme will write to you to say, do you want this pension or not? And then it will be up to the employee to continue the pension or to opt out of the pension. However, this should be clearly be mentioned in terms of the employment contract and agreement. um, it is not something that is decided between the employer and the employee to just say, oh, you don't want the pension, so we're not going to put you in your pension scheme. That is not lawful. The lawful procedure is you opt them in, they pay the first month, they are contacted by the pension company, then they opt out, and if they want to continue, they will continue in the pension. So you need to make sure that as an employer, you've explained this to your employee about the pension, and it's important to start saving for your future. Because pension is important, in as much as you'll be entitled to the state pension, but also to have a private pension is something that is of great benefit to each employee. Termination. The contract should have termination clauses within it. So how do you terminate the contract? When is it terminated? Under what grounds? Is it terminated under gross misconduct? What sort of notice is required? Final warnings and so forth. So the termination should be there. Notice periods after probation for both parties. Conditions for summary dismissal or garden leave. Garden leave is whereby the employer doesn't require your services anymore, but they're still paying you your salary, and they've terminated your contract. So everything that has to be in the termination has to be there. And also attached to termination or even to the main contract will be issues to deal with confidentiality, post termination obligations that will be on the employee. So that is things like you cannot compete against your employer, you cannot disclose confidential information to competition, you cannot start competition, or you cannot open a business within a certain radius from your employer and or former employer for that matter. So termination, confidentiality, that needs to be recorded in the employment contract, how the uh, company equipment is going to be returned to the employer. So if you've got uniforms, cars, mobile phones, books, and so forth, that needs to be returned. Usually, when people get to this stage, the relationship is no longer amicable. So it might be beneficial to both parties to include a third party, or at least someone who is neutral, because the relationship might have broken down in most cases. And so, to avoid any animosity, it might be important to bring someone to be able to mediate under these circumstances. Town law solicitors can be able to help you as well. Disciplinary and grievance procedures. If you are not happy with some things to do with your employment, no matter how small, sometimes it is important to raise it up with your employer so that issues are addressed before they boil up. So you can raise a grievance with your employer. Likewise, if the employer has got something that they need to deal with you, if you are, in quotation marks, misbehaving or bringing into disrepute the company, or not performing so well, underperforming, or you are breaching the company policies and contract, then the employer might call you for a discipline. And again, the disciplinary procedure should be part of the documents that the employee have got access to. Likewise, the grievance procedure. In the disciplinary, the process should be followed, i.e., notifying the employee of the charges against them or the allegations against them, giving them time to prepare, allowing them to bring in to be accompanied to the hearing by either a trade union member or someone who is permissible under the employment handbook, a family member or a friend. Most of the times, companies don't want solicitors to attend this type of meetings, so you have to check before you ask a solicitor to attend with you. And for the grievances as well, the employers should deal with grievances in a just and fair way, not just to give lip service to what the employees are complaining about or what the employee is complained about. But you need to get this information through your employment contract and or your staff handbook, your employment handbook. Data protection, again, is also linked to confidentiality. GDPR is important, particularly if you are dealing with people's or the company's sensitive information, which is always mostly the case for most people, that the information is always or usually very sensitive. In the event that the terms of the employment changes, it's important to do a variation contract. If you're going to do a variation or a schedule of changes to the contract, then that is important that this should be done. Most times people change the terms of the contract without necessarily noticing that they've changed. It just becomes clear and apparent when there is a dispute and people are now producing the audit documents which are no longer fit for purpose because over time the responsibilities, the terms have moved from when the employment started. So it's always important to make sure that your employment contract is reviewed and take that opportunity when you do your appraisals, your supervisions, to you make sure that everything is still the same or is still relevant to what you are doing. Supervisions can be done anytime. I would say maybe every 3 months do supervisions. Appraisals that are done annually, and so forth, so that the terms or the variation of terms can be discussed between the employer and the employee. The contract would normally mention that that is the entire agreement, and either by itself or in conjunction with the documents that it refers to, such as the employment handbook. So you should be aware of any other documents that forms part of the contract, so that when you are going to court, if need be, you've got all the documents. So this is a quick rundown of what is supposed to be in a contract of employment. Some people do not bother reading the employment contracts, but I would say please read through employment contracts, understand them, and see that they are relevant to what you are doing. In terms of employment of sponsored employees, people that have come from outside the country, there is an additional element of visa or home office requirements. You need to have your leave to remain, your leave to enter, your visa in the UK. The employer will conduct right to work checks on you and to make sure that you also have done your e-visa and all your information is up to date. The employer, you've got your next of kin information. I always say to employers, if you've got an immigrant or even someone who is in the UK on as a British person or with settlement, to have at least two people that are next of kin, particularly for immigrants, one in the UK and at least one outside the country from their own original country. Because in the event of anything happening, you might need to communicate with the people that are abroad in relation to your employee. So sponsored workers have got an additional element to their employment contract. So some of them as well, the additional requirements for sponsored workers would be that they get paid a salary that is normally above the minimum wage in the UK. The Home Office has got its own minimum requirements for such people to be given a visa and to be effectively be in this country. So if you've got any questions in relation to employment law, you can get in touch with Tan Law Solicitors who will be able to help you. We can help you if you're an employer, even if you're an employee. Anything to do with employment, we'll be able to assist. Starting from the drafting of contracts, drafting of staff handbooks, policies, we can help you with that. If you're an employee and you don't understand your contract or you believe your contract has been breached by the employer, we can help you with that. If you're an employer and maybe you've been taken to ACAS or you've been taken to the employment tribunal, you want to respond through your ET3 and you want to submit your defense, we can help you with that. You're an employee, and you want to draft your particulars of claim, draft your ET1 form, we can help you with that. Thank you so much for tuning in. My name is Anthony Mayara from Tanlo Solicitors. You can find us on YouTube, LinkedIn, Facebook, on our website, and you can call our offices if you require any information. Until next time.